Good afternoon and welcome. As president, it is my distinct pleasure to call to order the 2102nd stated meeting of the American Academy of Arts and Sciences. I'm pleased to see so many Academy members who have joined us for this Morton Mandel conversation, which is made possible by the generosity of the Jack, Joseph, and Morton Mandel Foundation. Morton Mandel's vision of a program for civic discourse and membership engagement allows us to gather from across the country and exchange ideas on essential topics. We're forever grateful for his generosity and the opportunity to connect Academy members in this way. I also want to take a moment to express gratitude for Academy member Frances McCall Rosenbluth, whom we sadly lost last month. As one of our most active and engaged members, Frances served the Academy in so many capacities, including as New Haven Program Committee Chair. Today's event was her idea, and I hope that you will join me in remembering Frances for her friendship, her leadership, and her intellectual contributions to the Academy, our nation, and the world. We miss her greatly. In addition to being a chance to gather Academy members, today's conversation is in keeping with the Academy's work on American institutions, society, and the public good. As an institution, the Supreme Court is central to the difficult questions related to democratic citizenship, inequality, and civil justice that recent Academy projects work to answer. At this consequential moment for the court's history and for our democracy, I'm especially grateful for this chance to discuss. The Academy is proud to have several Supreme Court justices among our membership, including Chief Justice Roberts, Justice Sotomayor, Justice Breyer, Justice Kagan, and retired Justices O'Connor and Souter. Historically, the Academy roles have included such influential justices as Ginsburg, Scalia, Rehnquist, Brennan, Warren, Marshall, and Jay, among many others. Today's program is an opportunity to gain an understanding of this essential and often impenetrable institution and its members from an Academy member whose insight into the Supreme Court are unparalleled. Today's speaker is Linda Greenhouse, the Knight Distinguished Journalist in Residence and Joseph Goldstein Lecturer in Law at Yale Law School, and a Pulitzer Award-winning columnist for the New York Times, where she has written about the court for more than 4 decades. Linda was elected to the Academy in 1994. She has made multiple contributions to Daedalus and sits on our council, Committee on Studies and Publications, and the New Haven Program Committee. Linda is currently serving as president of the American Philosophical Society. Her most recent book, Justice on the Brink, The Death of Ruth Bader Ginsburg, The Rise of Amy Coney Barrett, and 12 Months That Transformed the Supreme Court, was released in November. We'll begin with opening remarks from Linda, but the majority of our time is dedicated to Q&A. When the time comes, please use the raise hand function located under the Zoom Reactions tab to indicate that you have a question. Linda, let me turn things over to you.
Thank you, David. It's a pleasure to be here. So I have a question. Was that John Marshall or Thurgood Marshall, who was one of our members?
That's a good question. I believe it was Thurgood Marshall, but do others know the answer to that question?
It could have been John Marshall.
It could have been John Marshall.
You go back long enough. So
Justice Jay, I believe, would be way back. Am I correct? I don't know all of my history.
Fourth Chief Justice, right? I was going to mention Frances Rosenbluth also, and I know she would have been here, and I do miss her. We all do. So I'll just start with a few framing remarks. And as David said, this really is going to be a conversation. So my husband said to me the other day, "Why, the Supreme Court just seems to be lurching backward." And of course I said yes, but then I said, that's not quite the adequate way of framing what's going on. It's more than lurching backward. It's not just going back. It's doing something. And it finally came to me what is happening. The Supreme Court has been weaponized. I think that's really the way of putting it. We have here, and this is what my book is about. My book is a chronicle of the year, the term's last term, the amazing term of 3 Trump justices sitting on the Supreme Court, 3 justices who were handpicked to deliver what they are about to deliver, that is to say, overturning Roe against Wade. it's really incredible. I cannot think of another time in the court's history. I don't hold myself out as a historian. I'm not. But if you just think back, of course, conservative presidents have wanted to project their philosophy onto the Supreme Court, knowing that justices they have a chance to name will far outlast their own administration and will be a major part of their legacy. We understand that. That's normal. The Supreme Court has always been an organ of our domestic politics. So Richard Nixon in 1968 ran against the Warren Court, right? Ran against the criminal procedure achievements of the Warren Court. He used crime as kind of a dog whistle. He really wanted to talk about race, but he knew he'd be understood to be talking about race. He didn't actually have to mention race. And he got 4 appointments and made very good use of them. That's okay. We get that. This is something different, where a Republican president announces as a candidate, I'm going to put justices on the Supreme Court who are going to overturn Roe against Wade, and then he does. It's targeted. It's like a targeted guided missile. So, how did this come about? Well, there's a long history to it. The Republican Party has pledged its presidential candidates since Ronald Reagan in 1980 to pick those judges and justices who would overturn Roe against Wade. It's been the signal, cry, call, agenda item for the National Republican Party. Whether individual Republicans believed in it or not, it's been an instrumental choice to rally a base. And it's a small base, only according to the polls, only 20% of the American public would like the court to overturn Roe. That means 80% of the American public doesn't want that to happen. We have on the court today 6 conservative Catholic justices. We have 7 Catholic justices. One of them is Sonia Sotomayor. We have 6 conservative Catholics on the court. I include Neil Gorsuch, even though he currently is an Episcopalian, but he was raised Catholic and went, in fact, to the same elite Jesuit boys' school that Brett Kavanaugh did. This is not a coincidence. I talk about this in my book. I say that, this is not often mentioned. Well, now it's mentioned a little more, but for years was not mentioned in polite society because religion is the last taboo. We can talk about people's sexuality, their gender identity, their behavior in all kinds of contexts, but we can't talk about religion. Well, we need to talk about religion. And what's striking about this is that Catholic women in America have abortions at exactly the same rate as non-Catholic women. So it's not that the Catholic Church is a monolith. It certainly is not. It's not that to be a Catholic places you in any particular position. It certainly doesn't. But it just happens that these hand-picked justices on the Supreme Court are all of a like mind on this subject. So it presents a crisis for the court. My colleague at Yale, Christina Rodriguez, has just come out with a fascinating piece in the Harvard Law Review, which you can get online. I commend to you. It's called Regime Change. And what she's talking about is that there's one regime in our domestic politics, the politics that led to the election by millions of votes of President Joe Biden, a politics that wants government to be in service of the people, a politics that recognizes the social changes that we've seen in our lifetime. And then there's another regime. It's the regime on the current Supreme Court. And they are at absolute odds. And to a degree that it's hard to find a historic analogy. So what this means for the court, we hear a lot about legitimacy. It's almost become a buzzword. Oh, the court better watch out or it's going to lose its legitimacy. What does that mean? We don't actually know what that means because we've never seen a situation like this. So we're going to have abortion this term. We're going to have the Second Amendment, big gun rights case that was argued last month, and I think there's no doubt that more Americans are going to be enabled to walk around with concealed weapons as a result of the way the court's going to decide the case from New York. And we've got religion. We've always got religion. And there's a case being argued tomorrow that will result, I'm quite certain, in the channeling of more public money to pay for tuition at parochial schools. So maybe I'll just stop it there and take this in any way you'd like. I'm happy to get in the weeds of any of these issues, or keep it more general, or I'm actually very interested in the questions that are going to come from this very special audience. Thank you.
Good. So please do raise your hands to ask questions. And I'm seeing some hands go up. I do see one in the chat already. Please don't use the chat, but I will read this one. If the present court overturns Roe versus Wade, would a future Supreme Court be able to reinstate it?
Well, sure. They could, but it's, you know, the center of gravity on the conservative side of the court right now is pretty young. So I don't think that would change very quickly. It's taken 50 years to undo the right to abortion, and it's going to take a while. I mean, I think the only remedy as a practical matter lies in our domestic politics. A decision that erases Roe against Wade can itself be erased by legislation. There's legislation pending in Congress that would protect the right to abortion. Now, obviously, the current Congress is not about to do that. So that tells us that people that want to get motivated on this issue had better start working at the grassroots level, just like the other side has done for a couple of generations now.
Thank you. A question from David Schatz, if you want to unmute.
Yeah, thanks very much, Linda. Thank you very much for doing this, and the wonderful forum. I mean, the overturning of Roe versus Wade could be an absolute disaster for millions of women in this country. It'll obviously be very geographically divided in the impact. I'm wondering, I'm sure you've thought about the long, short, and medium political impact of overturning. As you point out, Roe v. Wade has been this focal point for conservative rallying for decades. When they no longer have that as a rallying point, do they need to be careful about getting what they actually wished for, in the sense that there could be pretty substantial backlash? Presumably, women who don't want to see it overturned, even those living in relatively conservative areas of the country, are going to be, some of them are going to be pretty unhappy about this.
Well, we'll see. I mean, would I take to the bank the assumption that there'll be an effective counter mobilization? I wouldn't, actually. I think, for one thing, there are many obstacles, one of which is gerrymandering at the state level. And we see that going on right now, right in front of our faces, as a result of the 2020 census and what the Republican Party is trying to do to kind of lock up majorities in legislatures around the country. I can see mobilization on both sides. So what do I mean by that? The next step, if Roe against Wade is overturned, it simply means there's no constitutional right to an abortion. It's certainly not a constitutional prohibition against abortion, unless the court should deem that the fetus is a person that is entitled to the protections of the 14th Amendment. And that's a real movement on that side of the street. And it may sound, kind of unlikely. I don't think it's 100% likely, but I think that could well be a mobilizing tool on the other side. So I think we're going to see a very multi-layered and complex political reaction if the court does what we think it's going to do.
Thank you.
Elena Fuentes Affleck.
Professor Greenhouse, greetings from San Francisco. This is Elena Fuentes Affleck at the University of California, San Francisco. Thank you so much for sharing your thoughts. I wanted to ask a question about the context in which the Supreme Court is operating. Because of all of our institutions, it is so strongly grounded in precedent. And you noted the unique constellation of justices who are currently serving on the court. And wondering, you said there hasn't been a particular precedent for this constellation that we see before us now. How has the court, are there any other inklings that you can glean from the Supreme Court history that might help us understand what may be coming, even though we don't have a definite roadmap?
Not really. You know, I've been trying to think hard about this. And of course, you know, one episode from American history that people often raise is the struggle between Franklin Roosevelt and the Supreme Court. But that was different in, I think, in every way that counts. So for instance, you know, Roosevelt came into office and he inherits a Supreme Court that's grounded in the past, right? I mean, they weren't picked for that reason. They just, you know, had gotten old. And the Depression came and FDR is elected with overwhelming political majorities. And this court stands in his way. And eventually he prevails by naming people who you could say, I mean, somebody could say to what I said in my opening, well, you know, he tried to weaponize the Supreme Court, didn't he, in terms of getting the New Deal programs upheld instead of overturned. To which I would say, but those were programs that Congress, by very strong majorities, had given to a president, reelected with very strong majorities, given the president the power to enact. So in other words, the court was simply being asked to ratify what the people wanted. And here we have a court that is going to exercise its power to do exactly what the people don't want. So I don't actually, I mean, there may be people on this call who are better historians than I am, and I welcome their intervention, but I cannot think of a historical parallel for what's going on now.
Let me throw a question related to that in. Justice Sotomayor last week expressed concern that the public reputation of the court will not survive the stench of a decision on Roe v. Wade. What do you think is the public perception of the court, and how concerned should we be about its legitimacy, and how concerned are the justices about that?
Okay, that's a few different questions.
Yeah.
It's a fact that the American public pays very little attention to the court. Usually, the court's kind of remote. Much of what it does is highly technical, doesn't affect everybody's, you know, anybody's daily life. Now they're paying attention, it seems, because I see Mary Beth Norton on the call, so I defer to Mary Beth's knowledge of history, and I hope she weighs in. So I just interrupted my own train of thought. So we saw when the court allowed the Texas vigilante law, SB 8, to go into effect without a hearing, without any kind of review on September 1st, the Gallup poll indication was that public respect for the court plummeted from the high 50 percentile, which is pretty good given that Congress is down around 12%, down to 40%. So the court has the public's attention. Do people care? Does the court care about this? I think some of them do and some of them don't. You know, I think the general perception, and I share it for what it's worth, is that Chief Justice Roberts is attentive to what people think about the court. I think he's quite attentive to what history is going to say about the court that has his name on the door, which is the Roberts Court. But those kind of concerns, which may factor into kind of day-to-day actions of the court, or even, let's say, the Affordable Care Act, we know about that. This is an agenda item. Abortion is an agenda item. these justices, I mean, I think Coney Barrett was maybe a year old when Roe was decided. And, you know, she was raised in this very conservative Catholic community. And I think she was just raised with the notion that here's an atrocity of historic dimension, and it's part of everybody's obligation, if they're in a position to do anything about it, to get rid of it. I mean, it's just a different kind of thinking. So I think those that agenda outweighs whatever might, in an ordinary kind of case, be the court's concern about its, quote, legitimacy. So should we care? Should people like us on this call care? Yes, I think we should care, but we need to care in a certain, in a kind of clear-eyed way. I think many of us grew up in the shadow of the Warren Court, imbued with the notion that the court, at the end of the day, is a force for good in the country. The Warren Court had basically harnessed the Constitution as an engine of social progress, social reform. Not, I might add, having anything to do with women. The Warren Court never once recognized discrimination on the basis of sex as being a constitutional harm. We'll set that aside, but certainly in race and on criminal defendants' rights and so on. But, you know, that the Warren Court was really an anomaly in the span of American history. And there's a certain regression to the mean doesn't capture the dimensions of what's occurring. But I think we have to detach ourselves from the notion that the court is a force for progress as an institution historically in this country, because it really hasn't been, and it's not going to be right now.
Mary Beth Norton, would you like to have a question or a comment?
Yes, I would. Linda, I didn't mean to cause you any problem by showing my face finally. I actually just want to align myself with the comment you just made about the history of the court. For years, I taught constitutional history. I haven't in a long time, but I always discovered that when the students at Cornell came in as worshipers of the Supreme Court, and one of my main points in the way I lectured in the course and taught about the court, what court was to say, sorry, this is not what the history of the court has been. And that when you think about the court as a force for positive advances, which they all did when I was teaching, and I assume they still would too if I were teaching the course anymore. In any event, what I wanted to say with respect to historical analogies is that the only one that has occurred to me is that could occur not immediately, but in the aftermath of an overturning of Roe v. Wade, and in part depending on how the court does it. And I have to say, Linda, I'm a great admirer of your recent column about gaslighting in the court, because I listened to that argument and I thought you were so right on about what you said about what the various members of the court said. But I also think that Justice Sotomayor was right on when she talked about stench, because if you think about it, what is one of the most reviled court decisions ever? And it was intended at the time to resolve a major problem, and that was Dred Scott. And I've never heard anybody make that analogy. And I wonder, Linda, what your response to that analogy on my part would be.
Well, it's so interesting, Mary Beth, because on the anti-abortion side of the street, Roe against Wade has been commonly analogized to Dred Scott. Mm-hmm. And, you know, one of the things that we heard from Brett Kavanaugh during the argument last week was that, well, you know, the courts overturned precedent, the courts overturned these terrible cases, the court, Brown against Board, overturned Plessy against Ferguson. So what's the problem with overturning precedent? I thought, you know, that's the other side of the coin, isn't it, Brett Kavanaugh? Mm-hmm. You know, your side has analogized Roe to Dred Scott, and now you're saying that overturning Roe would be analogous to Brown against Board, overturning Plessy against Ferguson. Please, I mean, please stop me from going down that road of screwed up thinking. So, you know, that's my response to what to what you said. I mean, Dred Scott obviously, brought us the Civil War, and there's a lot of things going on in the country today that some people think is kind of tending toward certainly a cultural civil war, if not an out-and-out shooting one. And this would be part of that ammunition, I think.
Well, if I can just add a little bit, I mean, Tawney in his decision was really trying to resolve. I mean, it's interesting because he's trying to resolve what is a very contentious issue through a judicial decision. And in a way, if Roe is overturned, then it does the opposite. That is, it takes what has been a judicial decision back into the states. But I still think that that it's a decent analogy in the sense that I think that if the court does what we think it's going to do, then Sotomayor is absolutely correct that in the long run, the decision is going to lead to a denigration of the Roberts court in the same way the Tawney court has long been denigrated. Although the Tawney court did many interesting and good decisions, it's been known by Dred Scott.
Mm-hmm. Oh, I think that's right. I mean, the one thing that occurs to me to say, some people say, well, this will just turn the issue back to the states the way the court should have done in 1973. The Justices Brett Kavanaugh was busy saying, well, the Constitution is neutral. We should be neutral too. So I'll just mention, for 1 second, a little bit of history, which is that, the vote in Roe, and Mary Beth, if you would ask your students what was the vote in Roe against Wade, they would all say 5-4. I bet it was 7-2.
7-2, yeah.
This 7 included 3 of Nixon's appointees, right? It was not a political issue. It really wasn't. It had broad support in the public, and in fact, the NORC survey in the immediate aftermath of Roe, support for legalized abortion actually went up in the country after Roe. There was not a spontaneous backlash, which is the mythology, but rather there was a carefully cultivated backlash with the goal toward the party realignment, the partisan realignment that eventually occurred. The Republican Party carefully nurtured a base that was opposed to Roe, but it took the better part of a decade for that to occur. I'll just mention one more thing and then get to more questions. But the first justice who was named to the court after the court decided Roe was John Paul Stevens. Mm-hmm. He was President Gerald Ford's only appointee to the court. He succeeded William O. Douglas, who of course was a member of the majority in Roe. And John Paul Stevens was, Republican appointee. He did not get a single question in his confirmation hearing about abortion. Why not? Because it wasn't a political issue. In 1975, almost 3 years after, December of 75, almost 3 years after Roe. So, the things that we assume today were true were the opposite. It's very counterintuitive, but it's worth keeping in mind as we go forward.
Altacharo.
Thanks very much, and thank you for this conversation. It's fascinating. I'm Altacharo, a University of Wisconsin law professor. I wonder, Linda, if you could talk a little bit about what you think the effect of this overturning of Roe will be on related issues. I mean, Roe built on a series of contraception and other decisions about right to privacy and the notion of the right to procreate. And since then, there's been a kind of thinking about reproduction in the context of fundamental rights that has affected everything having to do with reproductive technologies and to some extent the right to die. And we've seen politically in the states in the last decade that have tried to pass so-called personhood amendments to make an embryo a 14th Amendment person. They always fail, even in the conservative states, because of the unintended consequences, like essentially outlawing in vitro fertilization. There are just too many people that are grandparents now because their kids were able to use IVF. So I wonder if you can just speculate on how they're going to accommodate the overturning of Roe jurisprudentially in the face of all these other kinds of affected issues?
Yeah, that's a really interesting and deep question. And, you know, Amy Barrett actually kind of raised that question during the argument, where she said to the Mississippi Solicitor General, who was arguing, you know, on behalf of the state law, well, if we buy your argument, basically, what are we buying? What else is at stake? And he, of course, had to say nothing else, because, and he gave a crazy reason, a ridiculous reason. He said, it's because these other cases, you know, have a bright line that we can understand what they're about. You know, same-sex marriage, which you could say is an outgrowth of the whole fundamental rights, you know, chain of cases that you mentioned. You know, you're either married or you're not married. So courts don't have to, you know, get into the weeds of that, or, you know, that obviously that's not the answer. That makes no sense. Yeah, I mean, we're dealing with fundamental rights in the substantive due process, you know, part of the forest, and the court's going to have a problem. You know, they're going to try to do something kind of tricky and technical and talk about, you know, rational basis review and deference to state legislatures and all that kind of thing. But there's no logical boundary, it seems to me, if they go down that road, and they're going to have a challenge in the writing. They may know, you know, they conferenced on the case last Friday, let's assume, as they do every week with the cases that they've heard during the week, and they took their straw vote, and somebody's been assigned to write the majority opinion, and that's fine. They've got a bottom line, but is it going to write? What are they going to say? Could be really important going forward. You're absolutely right to raise that.
Question from Irving Wolodatsky-Berger. Irving.
Hi, this is very interesting hearing you. And let me ask another question about unintended consequences. And this is less legal, maybe it's to political sciences in the audience, but there could be big economic consequences to Roe v. Wade being overturned. Few examples. BMWs are manufactured in the US in South Carolina. I'm assuming South Carolina will be one of the states that would not support Roe v. Wade. I don't know for a fact, but I suspect that most BMWs are sold in blue states. You could have an economic boycott of BMWs as a result of a reaction against states getting rid of what, as you said, Dr. Greenhouse, us taking a woman's right to choose as a basic principle in the country. Also, another example, Austin, Texas is a big technology center. Tesla is supposed to move its headquarters. So if I go walking around MIT, with which I'm affiliated, and I start asking young women, would you like to go work in Texas? They may say, are you kidding? I mean, this goes all against my principles. It's not far from asking a question if you would be happy to go work someplace where Blacks are second-rate citizens. Is that a possibility, or am I just making up thoughts?
Well, I think there's probably some data on, I think there is, on the extent to which we, as Americans, are sorting ourselves into where we choose to live. So, yeah, I mean, I could certainly see a kind of a brain drain, or a, you know, refusal to add brains to some of these states. You raised the issue of boycott, and that's pretty interesting, because the states that attempted to pass anti-LGBT legislation in the past few years. Corporate America rose up and said, we're not going to put up with this. And the states backed off. Why did corporate America rise up? Obviously, because gay people in their workforce and in their
customers, don't forget.
Customers and workers, and are now, free to be out. And, this has become unacceptable. So when these states started passing these bad abortion laws, for instance, Georgia. So Georgia has a huge movie and television film industry because they give some of the best tax credits in the country. And there was, for a brief time, a Hollywood boycott of Georgia. It didn't last very long because the tax incentives were simply too appealing to the producers who finance these films and these TV shows. I wrote a column during the past year that said, hey, corporate America, you were so effective in protecting LGBT interests. How about doing the same thing for women's rights to reproductive freedom? And, there's American Airlines, based in Texas, and, Dell Computer based in Texas, and, and silence.
Well,
so,
because Roe v. Wade was alive and well, but that could change radically if all of a sudden that disappears. And remember, it's not because they are taking the position. The marketplace is very strong. And if your employees and your customers say, screw you, I'm not going to fly American, then you have a big problem.
It's really interesting. I mean, I won't say I'm eager to see what's going to happen, but I'll watch this with real interest. We all should. Thank you.
Let me see. John McCarter, were you trying to ask a question a few minutes ago? I'm not sure. Are you there? Yes.
Yeah.
Great. I'd like to focus, Linda, on two people, Kavanaugh and the Chief. The Chief Justice is a scholar and an historian, and he has gone through Dred Scott in great detail, drafts 1, 2, 3, 4, and 5, and how it got worse and worse as Tawney rewrote it. He also confronted Trump Thanksgiving, 4 years ago. There are no, Republican courts or Democratic courts. There is the Supreme Court. A letter that he wrote with just deep emotion. And you mentioned the Roberts Court versus the Tawney Court. I think the Chief Justice, or I would ask, is the Chief Justice predisposed to a continuation of the Roberts Court in high esteem? And I think back to the Affordable Care Act, how he worked through that. Then I go to Kavanaugh and the exchange with Senator Collins at the time of the confirmation, and in which he talked that he was not of a mind to overturn Roe v. Wade. Do you see any opportunity that Kavanaugh and Roberts could get together with the other three and do a 5-4 that would be some sort of very narrow treatment or alternative, a salvation of Roe v. Wade?
Well, of course, the chief acting alone is powerless to stop what's happening, even if he were inclined to, because he's got the 5 to his right, including Kavanaugh. Part of what I chronicle in the book is his loss of control. And that was initially manifest in the religion area, where the new majority, once Amy Barrett came on the court replacing Justice Ginsburg, the court flipped and chose religion over public health in striking down the capacity limits on indoor gatherings that included indoor gatherings for worship. And Roberts was in dissent in those cases with the 3 justices to his left. and Kavanaugh was in the majority. Kavanaugh is a very thin reed. You said when in his interactions with Susan Collins, he didn't have in mind to overturn Roe. He didn't acknowledge any desire to overturn Roe, but I wouldn't purport to say I knew what was in his mind. And certainly his questions last week, his kind of casual, oh, well, we've overturned this and we've overturned that and we've overturned that. So what's the problem with overturning precedent? I just didn't hear any willingness from him to give the Chief Justice cover, assuming the Chief Justice wants cover. So I'd be, as a citizen, I'd certainly be happy, but as an analyst of the court, I'd be shocked if it came out 5-4 to retain a right to abortion.
So chances are slim to none.
I'd be happy to be surprised, but I'll mention about Kavanaugh. I think a real giveaway for him, at least in my book, was what happened a couple of terms ago. The last major abortion case that the court had was a case called June Medical. June Medical is an outrageous situation where Louisiana had a law that required doctors who perform abortions to have admitting privileges in local hospitals. It was outrageous on two grounds. One, obviously, the law was intended to shut down the abortion infrastructure because Louisiana hospitals were simply not credentialing doctors. But two, only a couple years earlier, the court, in a case called Whole Woman's Health, had struck down the exact same law from Texas, coming from the exact same federal appeals court, the Fifth Circuit. The Fifth Circuit said, well, that was Texas, and this is Louisiana, so we're going to uphold this law. Outrageous. So it came, the abortion clinics in Louisiana came to the court with an emergency application, put the Fifth Circuit opinion on hold, grant a stay so that we have time to file our appeal, to file our petition, for a couple of months. And the court granted the stay by a vote of 5-4 because Justice Ginsburg was on the court at that time. And Kavanaugh dissented. And he wrote a separate opinion explaining his vote. And he said, well, the doctor should just take a little more time and get those credentials. Well, if he had read the lower court opinion, he would have known, the district court opinion, that is, which had struck down the Louisiana law, he would have known that some of these doctors have been trying to get privileges for 5 years. And he just wanted to cover himself and look reasonable. Oh, just a little more time, and voted not to grant the stay. So, that's Kavanaugh when push comes to shove. So I just am not expecting anything from him.
If they overturn, the only places to get a legal abortion between the two coasts will be Colorado and Illinois. Is any member of the court thinking about the societal and economic impact of this total reformation of the availability of abortion? I think it's just extraordinary, the impact that this is going to have.
Well, there were something like 140 amicus briefs filed in the case, and a number of them on the pro-choice side make those points. So the court can't claim ignorance or surprise. It's all out there, and they're going to do what they're going to do.
Good. We have quite a few questions waiting. Erwin Shapiro.
I have an historical question that I'd like to ask Linda. If she would elaborate on her views as exactly why the Republican Party took it upon themselves to make anti-abortion a major characteristic of their philosophy, so to say. Is there anything to be learned from that?
Yeah, so I've actually, along with my colleague Reva Siegel, done quite a lot of work on this, and we've written it. What was going on in the second Nixon administration was an effort to do in the North what the Republican Party had successfully done in the South. So what do I mean by that? You remember the Southern strategy, which was to use race to peel the traditionally Democratic white voters away from the Democratic Party and turn them into Republicans. So the idea, cooked up by people like Pat Buchanan, Kevin Phillips, you might recognize these names, was, hey, we can do the same thing in the North. We can go after the historically Democratic voters among the urban, ethnic, white, Catholic population, traditionally Democratic, and we can play the abortion card just like we played the race card. And we can lure them over to the Republican Party. And in fact, a book that Reva Siegel and I don't want to say wrote exactly, it's a compilation of original source documents from what was going on in the pre-Roe era. It's called Before Roe versus Wade. And we have one episode where the Republican Party set up a table in the back of a Catholic church social hall so that people coming out of Mass could just sign up and change their registration. This was in California. So, that was the effort. And of course, it couldn't happen overnight. But after about a decade, they started making real inroads. And the evangelical religious right joined in that effort. And we have what we have today.
Thank you.
Howard Gardner and then Adele Simmons. So first, Howard.
Hi, Linda. I imagine I'm one of many who've learned most of what we know about the court from you over the years. Most of us do not want to wait until we have a different court, which could take 20 or 30 years. What are your views either about the commission that Biden appointed that I think is either reported or about to report, or something akin to a constitutional convention, which would really make it impossible to have the kind of packing for 30 or 40 years that we're now dealing with?
You mean getting rid of life tenure?
Yeah, that's right.
Yeah, I support getting rid of life tenure. It's an anomaly in the world. There's no other country that has endowed its constitutional court judges with life tenure. But that's a long game. I mean, even if, as you know, the US Constitution is, I think, the hardest constitution in the world to amend. So, but even if that could be done, we've got incumbents and on this sort of court packing issue. I haven't seen that as a terrifically productive road to go down because, one side can pack a few more in, and when the worm turns, the next side will pack a few more in. And, I think the answer has to lie in our elective politics. It has to lie in domestic politics. And, there are legislative solutions to most of these problems. The problem is a legislative lockup in Congress right now. And, I'm not an advocate for, telling the American public what to do. But if I were, I would say just pay attention to your local races and focus on Congress.
So, Linda, just to follow up quickly, as you know, the American Academy's report, Our Common Purpose, from our process of democratic citizenship, recommended 18-year terms and said that constitutional amendment was not required for that. Is this something that you would support?
Well, I mean, personally, yes. Now, I think, I understand the argument for a constitutional amendment not being required, but I think it's a contested notion, shall we say. And saying that it's not required doesn't mean it's not required. So I think that would be, litigated. And I think probably the better of the argument is that it would be required. But I would say go for it if, see if it works.
Okay, Adele Simmons.
Back on the abortion case, one of the things that hasn't been talked about much is that people sometimes make mistakes. I thought I was using absolutely all the proper birth control, and I wasn't. And I would have been an African-American, well, an African kid, American on my part, before I was married, and it would have ruined my career. The second one was more complicated, which was the amniocentesis showed I would have a seriously disabled child. And my college roommate had a seriously disabled brother, and she said her parents never paid attention to her, and she really urged me to get an abortion. I just think people's personal stories have an enormous, haven't been really talked about much, and these examples make it clear that people should have at least a right to choose.
Oh, thank you for telling those stories, of course. So about half the pregnancies in this country are unintended, and nearly half of those end in abortion currently for all kinds of reasons. And, you know, in terms of the amniocentesis, so, you know, some people have said, well, the Mississippi law bans abortion after 15 weeks. And, you know, 15 weeks is enough time. I mean, that was the Chief Justice's suggestion during the argument. But as you recall, and as I recall when I had amnio, when I was pregnant at the age of 38, you know, it's after 15 weeks. I forget exactly how many weeks it is. Maybe it's 18 or 20 that you can even have the amnio. So, yeah, I mean, and in the early days of the abortion reform movement, there were these speak outs where women would mass together and tell these stories, and they were quite effective. And that's been echoed in briefs that have been filed of groups of women telling their stories. But, you know, it's one thing to tell a story, but you got to have people listen to you. And we don't seem to have a majority on the Supreme Court that's willing to listen to those stories. That's the problem.
David Tatel, question?
I'd be interested to hear your thoughts about Justice Barrett's question about the easy availability of adoption. What did you think about the question, and how does that issue fit into the question of whether to overrule Roe?
Her question left me gasping for breath, actually. You know, what she said. So the argument to which she was responding was the argument that it's the availability of abortion as part of a woman's ability to control her reproductive life that has enabled women to be full participants in the economy and so on. We all know that argument. And she said, well, not really. She said, yeah, you can have the baby, but you don't have to be a parent. You can, she kept to both of the lawyers who were arguing against the state, the clinic's lawyer and the federal government's lawyer. She said, you know, there are these safe haven laws, you know, in which you can leave off your baby in a basket. And there's adoption. Why don't people talk about adoption? Said this mother of 7, 2 of whom are adopted. And, you know, it was so out of line, really. We're talking about a right.
Yeah, I didn't listen to the whole argument like you did, but did other members of the court pick up on the issue at all? Do you expect to see this issue play a role in the court's decision?
I don't think they picked up on it in the argument. I mean, it came from out of the blue. Will it play a role in the decision? I think if she writes separately, she's probably going to say something about that. I mean, what's so weird about what she said is that she was attempting to disaggregate that which cannot be disaggregated. That is, once you have a baby, you're a parent. Whether you leave the baby off in a basket or give the baby away to somebody else, you are going to go through the rest of your life having given birth, and you are a mother. She's got to know that. She's given birth to 5 children. So it just, as I say, I mean, when the argument was over, I had to leave my office and go take a walk in the cold winter sunshine because my head was just spinning.
Okay, thanks.
Peter Strauss.
This is more a question about damage control than anything else. One of the characteristics of Roe versus Wade is that it falls in what Charles Black once described as the unnamed rights, which have in some sense their source in a remarkably conservative opinion of Justice McReynolds in the 1920s. And I'm wondering, and Roe, when it was decided, excited some really aggravated criticism, not from the right, but from constitutional scholars. John Hart Ely comes to mind as a fairly balanced and respected character. And I'm wondering whether these characteristics of the opinion give any basis for thinking that, well, maybe the court could survive the stench.
Peter, if I understand your thrust of your question, I'm going to have to reject your premise. So, you know, there's been a mini industry in the law schools ever since 1973 about what's wrong with Roe against Wade. But I'm here to say that the reason Roe is the pressure point in our culture that it is, in addition to the politics surrounding it that I described earlier, is because it's about women.
Oh, I totally agree. I don't mean to be aligning myself with those critics. I'm simply asking whether the whole of the court's work is necessarily going to be impugned by what happens here, or whether it can be contained in the strange characteristics of unnamed rights that aren't in the Constitution directly, but have been recognized by the Supreme Court in the past.
I'm not 100% I understand what you're asking.
It's okay. I mean, let's go on to someone else.
Okay.
Okay. A question from Letty.
I may have missed this question because I lost connection several times during this hour, and I've asked you about this before, Linda, but I'd like others to hear your answer. The mention of the people, leave it to the people, struck me as incredibly disingenuous, since clearly the people means state legislatures. And we know where many state legislatures stand on this. So there seems to be a cloak over the states' rights argument so that it sounds all, you know, red, white, and blue, give it back to the people. Would you comment on that obfuscation, if you agree with me?
Yes, I do agree with you. And, you know, as I said earlier, I mean, yeah, starting with the notion that there are not any other fundamental rights that we just leave to the people. But even assuming that this were a right that we could leave to the people, the legislatures don't represent the people today.
Yes.
Because of gerrymandering and, you know, what we see going on very currently, like today. It's just a bizarre way to talk about something that's been been recognized as a constitutional right for almost 50 years. It kind of, you know, fits in with the other line of questioning during the argument last Wednesday, which was that of neutrality. And maybe this is what Peter Strauss was getting at. Well, you know, the Constitution doesn't mention abortion, so the Constitution must be neutral. Well, the Constitution doesn't mention marriage. The Constitution doesn't mention travel. The Constitution doesn't mention education. All these things that, you know, in our constitutional history have been recognized as rights. And so the notion of neutrality after 50 years after Roe is just another bizarre, you know, into another bizarre cul-de-sac.
Jane Ginsburg, question?
I want to go back to something that Linda said earlier, which is that most of us grew up thinking of the court as a force for good. And that certainly was true in my case. So what should we be thinking of the court as now, assuming that what we expect to happen does happen in some form or other?
Yeah, well, I'm sorry to say, I think we've seen a court that's been captured by a minority in this country. And I used the word earlier in our talk, weaponized. So captured and weaponized to accomplish with its power, the power that we've invested it with, that which could not be accomplished through the working of democratic legislation. And that's a tricky, dangerous place to be in a country as on edge as our country currently is.
Good. Please continue to raise hands if you have any last questions as we come to the last few minutes. Let me ask a question actually on a different topic. We've talked a lot about Roe v. Wade, but affirmative action. Many of us are associated with, of course, colleges, universities, affirmative action cases. Do you have any expectations for either this term or this court, and how things might be heading for that issue?
Well, so as people know, the case of Harvard's admissions policies is pending at the court. I say pending, the court hasn't granted it. When the petition was ready to be acted on, the court, instead of granting it or denying it, kicked the can down the road and asked the Biden administration for its views, which is a strange thing to do because we could assume the Biden administration's views, and if the court were to grant the case, the Biden administration would be perfectly free to inform the court of its views. So I read that, this was earlier this fall, I read that as the court thinking, well, we've already got abortion, we've already got the Second Amendment, maybe we don't need affirmative action right yet, that can wait. So the Biden administration has not yet filed its response to that, quote, invitation. They're expected to do that within the next few weeks, I think. And so the question would be, if the court was inclined to grant the challenge to Harvard's admissions policies, would it be granted a time to be argued and decided this term? The cutoff for that would be basically the end of January. If they grant a case after the end of January, it gets carried over to the next term. So are they going to grant this particular case? There's another case pending, which is a request to hear on an accelerated basis the challenge to the University of North Carolina admissions policy. So that would be the public university versus a private, but basically the constitutional legal questions are the same. I kind of doubt they'll take the Harvard case because the case went to trial. A very extensive trial that lasted for weeks. There's a very extensive record. And it's the facts aren't good for the challengers to affirmative action. Is there a majority on this court that would like to get rid of affirmative action? Absolutely there is. And there are conservative foundations who are funding this litigation that's going to be going on all over the country. So if they don't take one case or another case, they'll have the raw material. And I think it's just a matter of time. It was really only Justice Anthony Kennedy who kept affirmative action kind of going in the last round in the University of Texas cases, the two Fisher cases. And of course, he's gone. And so I think affirmative action is living on borrowed time.
Thank you. Michael Stryker.
Yes, Linda, you speak of the court as being weaponized. So do you think that if the January 6th insurrection had been somewhat more successful, that the court would have solemnified the, a future authoritarian dictatorship?
Well, no, but I wouldn't take a whole lot of comfort in that. So, there were quite a few cases that came to the court both before and after the election, brought by Republicans, challenging various aspects of basically the way that, in the name of the pandemic, deadlines were extended and mail-in ballots were made more available and so on. And there were some justices who were quite tempted to take these cases in the name of a constitutional theory that had not previously been endorsed by a majority of the court, still hasn't been, but is sitting out there, that of state legislative supremacy in deciding how to conduct elections. And of course, that's a very freighted question, because we see what's going on in some of these state legislatures now with their voter suppression agendas. So even though we avoided, anything that endorsed Trump's moves this time around, and leaving Trump very angry with his three justices who didn't do what he put them there to do, I think we're not in the clear if things keep going as they are in the legislatures and in the vote suppression efforts. I haven't directly answered your question about January 6th because no litigation I'm just not, I don't have a concrete enough idea of what the court would have been asked to do. But so I'll just leave it as saying I wouldn't rest easy that efforts growing, the cases growing out of the efforts to undermine our democracy will come out the way we would like them to come out.
Good. Well, thank you. I think we're coming to the end of our time. It's been a really wonderful conversation. Really appreciate everyone joining us. And Linda, thank you so much for joining us and for all of your insights. It's been a real pleasure to have this discussion with you. So let me wish everyone a very happy holiday season. Stay safe and be well. So I hereby dissolve the 2102nd stated meeting of the American Academy of Arts and Sciences. Thank you all for joining us.